now like to turn over the meeting to Veronica Gibbons. You may begin.
Thank you, and good afternoon, and welcome to today's webinar on the topic of telework and reasonable accommodation. My name is Veronica Gibbons. I work for OPM's Office of Work, Life, and Leadership and Executive Development. Today, we're going to cover a topic that continues to generate a lot of interest, some confusion, and a lot of questions for our team here at OPM. So we have assembled a panel of experts who are here to share important information regarding the importance of building the business case for recruiting and retaining a diverse workforce, including hiring employees with disabilities, the Telework Enhancement Act and OPM's role in providing guidance related to telework and employees with disabilities, and the Equal Employment Opportunity Commission's role in existing authorities. But before we get started, let's go over a few housekeeping tips. First, we encourage participants to use the conference call-in number versus using your computer to avoid any feedback. We also have available for download the handout and slides in the pod labeled webinar slides at the bottom right-hand side of your screen. Additionally, in order to make this webinar more interactive, we've included a few polling questions throughout, and we encourage your participation. The first polling question will go up momentarily and will tell us a little bit about the demographics of this audience. The next will go up towards the middle part of the presentation, and the last will occur just before the Q&A period. Although we have a designated Q&A time at the end of the webinar, you are free to ask questions at any time in the Q&A pod that is also towards the right-hand bottom of your screen. We have a lot of information to cover, so please rest assured that if we are unable to get to your question, we will provide responses at a later time. So let's get started. Over the years, both Congress and the executive branch have long highlighted the benefits of telework as a means to promote employment opportunities for workers with disabilities. In keeping with this goal, and in recognition of the 16th Annual National Work and Family Month, we are pleased to partner with the Equal Employment Opportunity Commission to talk about telework as a reasonable accommodation. Additionally, we have invited Cherokee Carroll with OPM's Office of Diversity and Inclusion to provide opening remarks concerning the business case for recruiting and retaining a diverse workforce, including the importance of hiring people with disabilities. So I'd like to go ahead and turn it over to Cherokee to give that introduction.
Good afternoon. Thank you for having me. Again, as Veronica mentioned, my name is Cherokee Carroll, and I'm with the Diversity and Inclusion Program Office, which is in the Center of Outreach, Diversity, and Inclusion here at OPM. We are just going to jump right in. When asked the question, why hire people with disabilities, most people would say because we have to, or because it's the right thing to do. Neither one of those answers are wrong, but neither really answers the bottom line. Neither really answers the question, especially when it comes to your bottom line. What is your bottom line? The same as everyone else's, meeting the mission through optimal performance. But before we get into that, let's address those common answers. Why do we have to hire people with disabilities? Here's a quick history lesson. Since the passage of the Rehabilitation Act in 1973, the federal government has taken numerous steps to increase the representation of people with disabilities in its workforce. These steps include President Bush's 1990 signing of the Americans with Disabilities Act, President Clinton's 2000 Executive Order 13163, prompting agencies to hire 100,000 people with disabilities within 5 years, the annual mandatory reporting of Equal Employment Opportunity Management Directive 715, President Obama's 2010 Executive Order 13548, recommitting the federal government to recruit, hire, and retain not only employees with disabilities, but those with targeted disabilities, and most recently, President Trump's reaffirmation to continue fostering opportunity for Americans of all abilities to apply their skills and talents in the workplace. So in essence, yes, federal agencies do have an affirmative responsibility to hire people with disabilities. Now, why is it the right thing to do? This often goes back to the old adage, see a need, fill a need. Agencies that hire people with disabilities out of a moral imperative are inspired to do something kind. Employment helps people with disabilities gain acceptance, independence, and financial security. Plus, their contributions decrease their reliance on public assistance, leading to a flourishing economy and reallocation of taxpayer dollars, a win-win for all involved. But then the question becomes, what difference does it make if I hire people with disabilities for compliance or as a good deed? I'm hiring them, right? Wrong. Hiring is only the first step. If you stop there, what you're doing is closing the door on opportunities to build a diverse workforce and foster an inclusive workplace, ultimately creating barriers to your success. To promote a diverse workforce and an inclusive workplace, it's necessary to develop a business case with a full understanding of the landscape. People with disabilities are the largest minority in the country, comprising nearly 50 million individuals, yet only make up less than 1/4 of a 2 million employee federal workforce. This signifies they are a severely undertapped source of talent. Disability is a demographic that permeates all sectors of society, from race and national origin, to gender and sexuality, to religion and socioeconomic class, and certainly has no bounds for age. People with disabilities are a diverse population with a set of knowledge, skills, and abilities they've worked twice as hard to earn after enduring insurmountable circumstances thrust upon them. People with disabilities have been excluded from or underrepresented in America's workforce based on the biases and stereotypes about their capabilities. They are presumed to be less productive than employees without disabilities and perceived as having performance issues such as limited work productivity, high absenteeism and tardiness, lack of dependability or dedication, as well as requiring additional assistance, training, and supervision. The persistence of such preconceptions make it difficult for managers to encourage proactive hiring of people with disabilities, and when they are hired, it's considered a charitable act that runs counter to organizational success and stakeholder value. Contrary to these beliefs, studies have found the difference in productivity between employees with disabilities and those without are statistically insignificant. Where there were productivity differences, employees with disabilities were more productive. Research also shows no difference in the need for supervision between employees with and without disabilities. Agencies will better serve their stakeholders if they reflect the diversity of their market base. Disability is not exclusive to the elderly, but as the U.S. population ages, the percentage of people with disability increases. The 2016 American Community Survey found that less than 1% of the under 5 years old population had a disability. For those ages 5 to 17, the rate was 5.6%. For the 18 to 64 age group, the rate doubled, and for 64 and over, the rate tripled. In the private sector, companies such as Deloitte recognize the buying power of minority populations and highlight that diversity is critical to growing market share and bottom line. In the nonprofit sector, clients are our customers, and they too see themselves represented in the organizations that serve them. Donors are also customers, and organizations and their clients can benefit from the resources of different groups. What's more, organizations with diverse leadership are more likely to understand the needs of a diverse client base. A 2018 study by Accenture reported businesses that actively seek to employ people with disabilities outperform businesses that do not. They had 28% higher revenues, 2 times more in net income, and 30% higher profit margins. Organizations and countries that tap into diverse talent pools are stronger and more efficient. Economists see discrimination as economic inefficiency, the result of a systemic misallocation of human resources. It's costly to have employees that cannot contribute to their full potential, or to have employees who are afraid of sharing their ideas because they know they may face bias or stigma from their colleagues. And yet still, it is more costly to settle discrimination, harassment, and retaliation claims. The expense is not only limited to litigation, but time employers must spend to defending claims, bad publicity, and damage to employee morale. According to the EEOC, there were over 24,000 disability discrimination charges filed, totaling more than $135.5 million in monetary benefits. In 2017, UPS agreed to pay $2 million to resolve a nationwide discrimination lawsuit for which the EEOC claimed the employer failed to resolve a nationwide discrimination lawsuit. to provide reasonable accommodations for employees with disabilities, and fired employees automatically when they exhausted the company's 12-month leave maximum. So let's get to the bottom line of high-value work. Corporate success translates into the public sector as timely delivery of services, innovative solutions to society's most difficult challenges, and quality customer service. These factors put the value in high-value work. To increase workplace inclusion and foster high-producing employees, try these practices. For this webinar specifically, I draw your attention to the last item, reasonable accommodations. It is a common myth that providing accommodations is expensive. In fact, the majority of workers with disabilities do not need accommodations to perform their jobs, and for those who do, the cost is usually minimal. According to the Job Accommodation Network, a service from the U.S. Department of Labor's Office of Disability Employment Policy, 57% of accommodations cost absolutely nothing to make, while the rest typically cost only $500. Diverse teams lead to better outputs. Author Scott Page uses mathematical modeling and case studies to show how diversity leads to increased productivity. His research found that diverse groups of problem solvers outperform the groups of the best individuals at solving problems. Diverse nonprofit organizations and the diversity of perspectives within them will lead to better solutions to social problems. Overall, only 36% of business professionals report that they feel empowered to perform their best work. However, when inclusion factors are present, this number noticeably increases. Employees are more productive when they feel they belong, are heard, and are able to be their authentic self at work. For example, those who feel they belong at their company, 73% say they are empowered to perform their best work. Beyond employee pride, feeling included, heard, and supported at work has an impact on employee productivity and success. When employees feel accepted and comfortable at work, they also feel empowered to do better. In the big picture, hiring and retaining people with disabilities falls in line with your agency's diversity and inclusion maturity as shown in this model. In stage 1, agencies are in the compliant phase and only focus on mandate-driven agendas. Their actions are largely reactive and mainly focus on meeting legislative and regulatory requirements. Stage 2 represents the moral imperative of, it's the right thing to do. In this phase, agencies are inspired to hire and retain people with disabilities, but the responsibility sits with a small few. Stage 3 is where agencies have a clearly articulated business case and they're starting to build and implement disability recruitment, hiring, and retention strategies systematically. At the operational stage, agencies are incorporating all aspects of disability employment into all lines of business through senior leadership accountability. Employees with disabilities are seen as an asset and catalyst for high performance. This is where we begin to really see cultural transformation happening. Stage 5 is where a diverse workforce and an inclusive workplace are recognized as a mission-critical imperative. The agency is recognized as a leader in disability employment, and employees with disabilities are fully integrated into all aspects of the organization. Now, ask yourself where your agency falls on this model. What can you do to change your way of thinking and recalibrate your recruitment and retention strategies to embrace and equip people with disabilities and harness their power to supercharge your workforce? Thank you for joining the webinar, and feel free to contact the Center for Outreach and Diversity and Inclusion with questions on disability employment.
Thank you, Cherokee, for that very informative introduction. We're going to move on. The next slide. So the question comes up a lot. What exactly is OPM's role as it relates to telework and reasonable accommodation? As many of you all know, the Telework Enhancement Act assigned OPM primary responsibility for providing telework policy guidance and consultative support services to federal agencies. Trainings such as this webinar represent one way for us to meet our responsibilities under the Act. In keeping with Congress's commitment to promote, next slide, please. Okay. In keeping with Congress's commitment to promote employment opportunities for workers with disabilities, the Telework Enhancement Act tasks OPM with responsibility for providing telework policy guidance as it relates to accommodations for employees with disabilities. You will find a wealth of information regarding telework and accommodations for employees with disabilities and other policy areas on our central website, which is www.telework.gov. The Cherokee did touch on some of the benefits of telework as a reasonable accommodation, and I'll just touch on it a little bit more. Telework offers significant benefits to employers and employees alike. For employees, telework benefits employees who are able to work but are unable to commute to and from the office for a variety of reasons, including mobility and energy level limitations, recovery from surgery or pregnancy, and/or ongoing medical treatments. For employers, by leveraging telework as a return to work strategy, employers can provide an environment for an employee to continue to be productive, mitigate the effects of a disability, and promote faster reintegration into the workplace, thereby increasing productivity. Next slide. So, although the Telework Enhancement Act assigns some policy responsibilities to OPM, our role in this area is actually very limited, which is why we rely so heavily on guidance that is issued by EEOC. As we see on this slide, in a comparison of the two statutes, the one thing that stands out is that while the Telework Enhancement Act certainly encourages the use of telework in the federal government, it does not mandate it or provide employees with a legal right to telework. On the other hand, the requirements of the Rehabilitation Act make it clear that telework may be considered a form of reasonable accommodation, even if an employee has been deemed ineligible to telework under the agency telework policy. It's also important to point out that the Telework Enhancement Act requires all federal agencies to have a telework policy in place, and the Rehabilitation Act requires that if employers have such policies in place, that employees with disabilities should have an equal opportunity to participate in those programs, unless to do so would cause an undue hardship. Another important takeaway is that when you're considering a reasonable accommodation request for telework, agencies should refer to their reasonable accommodation policy and not their agency telework policy. We know that telework is the preferred accommodation for most employees, so we have invited Chris Kaczynski with EEOC to address questions related to telework and reasonable accommodation, as well as his agency's role and responsibilities in this important topic area. Now, before I introduce Chris, I'd like for us to put up the next poll question so we can test your familiarity and comfort with telework as a reasonable accommodation. So, in introducing Chris Kaczynski is the Assistant Legal Counsel at the United States Equal Employment Opportunity Commission. During his career with EEOC, he has supervised the development of regulations, policy guidance, and technical assistance publications on Title I of the Americans with Disabilities Act and Title II of the Genetic Information Non-Discrimination Act, or GINA. Chris regularly advises EEOC field and headquarter offices on complex ADA and GINA issues. He has worked on numerous EEO issues in addition to the ADA and GINA, including supervising the development of enforcement guidance on pregnancy discrimination and related issues affecting the rights of LGBT persons in the workplace, and religious discrimination and accommodations issues. Chris has made hundreds of presentations on the ADA, the Rehabilitation Act, GINA, and other EEO issues, so I'm delighted that he has agreed to join us to share his wealth of knowledge on this important issue. So Chris, take it away.
Thank you very much, Veronica. And it's great to be talking to everyone today about this important topic. It certainly is a topic that we have noticed at EEOC in a very unscientific way, at least just based on the number of calls that we seem to be receiving in the last several years in particular, an area where there's just increased interest on the part of employers and individuals with disabilities. So we have seen this just increase, I think, significantly just in terms of the number of calls we hear from both federal agencies and agencies in the state and local government and private sectors. So it's a very timely issue to be talking about. It's a very important issue. It can sometimes be a sort of confusing issue, but we will try to strip away the confusion. And the first slide tells us what the objectives for the next bit of this presentation are going to be. This presentation should enable you to recognize when a request for telework is a request for reasonable accommodation. And by the way, that is a principle that applies whether the request is for telework or any kind of reasonable accommodation. Sometimes the request isn't obvious unless you know what the rules are concerning what accommodation requests look like. You should be able to understand the interactive process for determining whether telework is an appropriate reasonable accommodation, including whether a particular job can be performed remotely. And again, that interactive process is going to be characteristic of all kinds of accommodation requests that you may receive or that you may make if you're someone who's making an accommodation request, including but not limited to telework. So some of the principles that we'll be talking about concerning the interactive process are things that you can take away and apply to other accommodation issues as well. You should be able to resolve questions about how telework relates to leave, other types of reasonable accommodations, and employee performance and conduct problems. So in the next slide, we begin to discuss when telework is a reasonable accommodation. Telework isn't always a reasonable accommodation. And often agencies, and Veronica was just talking about it, have to have telework policies in place. And I think that most of the agencies that I've encountered do allow telework for many or most of their jobs. Some of them are limited to particular types of jobs, but telework is certainly an accommodation that we provide quite frequently in the federal government and have policies for telework that employees, whether they have disabilities or not, can receive. So if somebody, there may be an individual with a disability who is asking for telework under the normal telework policy that the agency has. Just because the agency may be aware that that person has a disability doesn't mean that that is a request for reasonable accommodation, and it should not be treated as a request for reasonable accommodation. It should be treated as a request for telework under the agency's regular policy and should be processed accordingly. But there are certain circumstances when telework may be a reasonable accommodation. And one is when the employer has no telework policy, likely not going to be the case in the federal government, or where the employee is not eligible for telework under the employer's policy. So in the example that we have in this slide, an employer, a supervisor requests 2 days a week of telework to help manage a medical condition. The employer's policy allows some employees to have 2 days of telework per week, but not supervisors. The supervisor's request should be treated as one for a reasonable accommodation. Certainly should not be ignored since the person has stated that it is for medical reasons. And it should not be ignored simply because the person falls outside of the group of individuals who normally are provided with telework. That is, the person's a supervisor and the policy doesn't provide for that. Does it mean that the accommodation will ultimately be granted or ought to be granted? Not clear from this example, but what it does mean is at that point the agency should begin engaging in the interactive process with the supervisor concerning whether the telework can be provided as a reasonable accommodation, whether it's needed as an accommodation, and if it would pose an undue hardship. So the next slide tells us that telework may also be considered a reasonable accommodation when an employee needs more telework than is available under an employer's policy. And the example is an employee who teleworks twice a week says she may need additional telework if she experiences a flare-up of symptoms related to her rheumatoid arthritis, and that affects her ability to use her hands and to walk. The employee supervisor tells her that if she cannot manage her disability with the telework schedule she has, she will need to use annual leave, and if she has none, FMLA unpaid leave if she experiences flare-ups on days other than those allotted her telework. So in this case, the employer may be violating the Rehabilitation Act if it says, and we'll talk about this point again later, you have to take leave instead of telework, instead of our modifying the telework policy. Again, can she be granted the additional telework to accommodate the flare-ups? That's a matter for determination through the interactive process. We're going to look at things like how often do they occur? Can they at all be predicted in advance? How long are they going to last? Is the person going, if they suddenly occur, is the person going to be able to have work to do while she is teleworking if she wasn't aware that the flare-up was going to occur beforehand? So these may all be considerations that one would look at in determining whether this is an appropriate accommodation, but the request should not be ignored, nor should the employee be told automatically you have to accept leave as either under the policy or under the accrued leave policy or under FMLA instead of using telework. Next slide. And telework may also be a reasonable accommodation when an employee needs telework under different conditions or circumstances from those under which the employer offers it. And this is similar really to the previous two slides that we've seen. Both involve situations where people needed something that the policy ordinarily didn't provide for. But here, a federal agency requires employees to work for 6 months before they're eligible for telework. And here's an individual who is the best qualified person for the position. That's in here not to tell you that you only have to grant telework for someone who is the best qualified person for a position or is receiving an outstanding performance appraisal. It's in here, that fact is in here just to indicate that under these facts, it looks like the person is probably going to be hired for the position, and the person says that she wants to have use telework immediately, begin telework twice a week as soon as she starts working if she's hired due to the effects of the disability. So this is another example of a situation in which an employer may have to grant telework even though the normal rule is you have to wait 6 months to get it. The next slide is a case that illustrates a similar kind of point, Natalie S. versus Department of Veterans Affairs. This is a rating veteran service representative with PTSD, and she requests telework, and the employer doesn't grant it and provides other accommodations, but says that additional telework would not be consistent with at the work at home guidelines because the employee had previously had a 10-day suspension and was not meeting performance standards. Now, one of the things that the employee argues here is that the failure to meet the performance standards is in part the result of the employer not having provided her with the necessary accommodations, including telework accommodations. So the poor performance may in fact be attributable to a denial of certain reasonable accommodations. EEOC concludes that the employer failed to provide an accommodation where it failed to consider whether telework guidelines could be modified or the complainant could be provided alternative telework arrangement. And interestingly, the decision, the appellate decision, noted the possibility of providing a 30-day trial period. And this is something I have a colleague who talks a lot about reasonable accommodation issues and emphasizes the importance and the utility of trial periods for certain kinds of accommodations. It doesn't say that they're necessary in all circumstances. Sometimes it's quite clear what the person is going to need and that the person is going to need it on an ongoing basis. But in some instances where it may not be clear whether the accommodation is going to work, a trial period is a good idea. After the trial period, the person can be made aware that it is a trial period, that the need for it will be reevaluated after the 30 days or however long has been taken for the trial period, and at that point, after a permanent implementation or an implementation of the accommodation for a longer period of time can be considered. Next, reasons that telework may be needed as a reasonable accommodation. Here's some examples. Flare-ups related to a disability. We had an example about that on an intermittent basis. Recuperation from the effects of a disability or a surgery or treatment. To avoid temporary adverse conditions in the workplace. For example, cleaning, construction, people with certain types of environmental sensitivities. Difficulty getting to the workplace because of a disability. And I emphasize this one because I see employers get tripped up with requests for telework where the problem the individual is having is that the disability is limiting or making it much more difficult or in fact preventing the individual from getting to work at the number of days that he or she needs to be there or maybe at all. And some employers will assume that because commuting is separate from what the person is doing at work, that the employer has no obligation to make accommodations related to difficulties that the employer that the individual is having with getting to the workplace. But that's not correct. The EEOC has said, obviously, an employer doesn't have to get the person to work. The employer doesn't have to, send a driver over to the person's house to get the person to work, or pay the person's cost of transportation or what have you if it doesn't subsidize or pay the cost of other people's transportation. But what it does have to do is make accommodations for things that are within the employer's control and that are part of the work environment. And one thing is where the employee has to work. That is something that the employer has control over. So there have been cases that have recognized that where someone needs a modified work schedule, may need to come in later and to leave later because of circumstances related to a disability, that the employer may have to grant that modified work schedule. Same type of thing with telework. If there's a reason that the person can't get to the workplace as many days as the employer normally requires people to be there or can't get there at all, the employer, because of a disability, the employer may have to consider telework as a reasonable accommodation. Laverne B. Versus HUD, the next case on the next slide, involves a situation that I think really could trip up an employer because it starts out with an employee who moves, who is granted it appears is granted the right to move to another location, or I guess just decides to move to another location away from his current office in Minneapolis to Madison, Wisconsin, for reasons unrelated to a disability. And this is to care for a family member. The employer's policy says you've got to come into the Minneapolis office 1 day a week. Well, it's a 5-hour commute from Madison to Minneapolis. And although that might be workable one day a week if the person leaves very early and then stays overnight and commutes back early the next day, that might be a possibility. For this person, it's not. The person claims that she requires telework as a reasonable accommodation because she can't do the 5-hour commute from Madison to Minneapolis. And the employer argues in this case that she's got to be able to do that. That's what the policy requires. I think it's easy for an employer to look at a situation like this and say, well, it's not the employer's fault that the individual decided to move to a more remote location from the workplace. But it appears from the description of the policy that the employer does typically allow people to work in these kinds of situations if the person one day a week comes to their home office. In this case, the person can't come to the home office, but says, let me go to the Milwaukee office. I can report one day a week to the Milwaukee office, which is much closer. I checked with Siri and saw that it's, I think, 78 miles from Madison, and Minneapolis is about 260 miles from Madison. So the person said, I can do that. I just can't do the 5-hour commute. And here, as we see on the next slide, still picking up with this same case, the EOC concludes, well, first of all, the agency argued that commuting is not a major life activity. So that relates to the point that we were just making, that employers sometimes think, I don't have to make accommodations that are related to commuting. EOC finds that telework is a reasonable accommodation for employees who have difficulty commuting. And full-time telework for this individual would not have posed an undue hardship, we concluded, because mail and documents could be scanned and sent electronically. Site visits were rare. Video conferencing could be used for meetings. The complainant could occasionally come, and the complainant could occasionally, although not once a week, come to Minneapolis. Just a note about the documents that could be mailed and scanned. I think that in particular situations, I don't know what the facts were here, but I think in particular situations where that the person needed so many documents scanned and sent, that it was really placing an undue hardship on other employees in the Minneapolis office in terms of getting their own work done. That might be a situation where the employer could argue undue hardship, but that does not seem to have been the case here. The interactive process, next slide, and these are principles that you can rely on, apply to any type of request for reasonable accommodation, no matter what it is. Generally, an employee has to request a reasonable accommodation. The employer and employee should engage in an interactive process to determine whether telework or some other accommodation, because someone might ask for telework but be able to be in the workplace with some other form of accommodation, is appropriate. The employer can get reasonable documentation of the disability and the need for accommodation where disability and the need are not obvious or already known. So the next slide breaks down sort of requests for reasonable accommodation, that first step, the thing that initiates the interactive process. They don't have to be in writing. Is it a good idea for the agency to have a record in writing of a reasonable accommodation? Yes, obviously it is, and you can ask the person who's making the request to complete paperwork to make the request for reasonable accommodation. But the point here is that if someone makes a verbal request for accommodation, any kind of time frames that the agency has for processing that request should begin with that verbal request. And if the individual doesn't reduce the request to writing or put it on a form, the agency shouldn't be stopping the process and saying, well, you made the verbal request, but you didn't fill out the form, so we're just not going to process it. If the form needs to be filled out and the individual hasn't done it, then the agency can fill it out. There may be a situation once an accommodation is put into place where you want the acknowledgement of the individual, to certain terms concerning the telework arrangement. That may be something the person acknowledges in writing, but you simply can't say to the person, we're not going to process the request because you didn't fill out the form. You don't have to use, the person doesn't have to use magic words, doesn't have to say reasonable accommodation, Rehabilitation Act, disability. All the person has to do is make some request for a change in the workplace, i.e., in this case, a request for telework that's needed because of a medical condition. It may come from a third party. Often that's a doctor, a medical professional. Person will come with the documentation and say, my doctor is recommending that I have these restrictions. Let's look at the next slide. Proper request for telework is a reasonable accommodation. An employee sustained a significant injuries to the right ankle in a car accident. The employee was not able to bear any weight on the ankle for a minimum of 12 weeks. Complications from the injury and the healing process resulted in the need for additional surgeries and an extended period of time when the employee would not have a severe mobility limitation. The employee requested to work from home during the long convalescence, but did not specifically ask to telework as a, quote, reasonable accommodation. She asked her supervisor to telework as a result of her injuries because she was using a wheelchair and because she could not drive. That is a request for reasonable accommodation. There's no word disability or Rehabilitation Act said there, and the request is still a good request. So determining whether an employee has a covered disability. This used to be harder. It used to be a more cumbersome, longer process. The employer could get a lot more information when the definition of disability was interpreted more narrowly than it has been since 2009 when the ADA Amendments Act changed all of that. In 2009, effective January 1st of 2009, under both the ADA and the Rehabilitation Act, definition of disability is construed much more broadly after the ADA Amendments Act. Minimal documentation should be necessary. Temporary impairments, including those that last fewer than 6 months, can be disabilities. And we'll see a little bit later when we talk about a case involving someone with pregnancy-related impairments that are disabilities. Something that's just lasts for a few months and requires the person to have bed rest during pregnancy could be a disability. It doesn't have to last for a particular period of time. It just needs to be limiting enough to be a disability during the time that it does last. And the accommodation is only granted for as long as the individual needs it. How do you determine if telework is an effective accommodation? Well, you identify the job's essential functions and EEOC's regulations. I don't cite them here, but at 29 CFR section 1630.2 .2 M and N talk about essential functions, and they give about 7 or 8 factors. We'll go over them when we talk about one of the cases. We'll see a number of those factors being used, but they involve things like whether the job exists to perform the function, whether there are other people who can perform the function, the amount of time spent performing the function, whether the position is highly skilled, such that the person was hired for his or her ability to do that function, terms of a collective bargaining agreement, terms of a position description, employer's judgment, and the consequences of not performing the function. Those are some of the most significant ones. Determining whether some or all of these functions can be performed from home. We say some because not everybody is going to need telework as a reasonable accommodation 5 days a week. Most people probably will not. Some people will, and in that case, all of the functions have to be performed from home. But in situations where a person maybe needs 2 days of telework or an additional day of telework, that person may be able to work on certain functions that can be done out of the office and then leave the ones to be done in the workplace to the days when he or she is present there. If marginal functions need to be reallocated to allow telework, determine whether the employee might have to take on other marginal functions to balance workload. So in order to be qualified under the ADA in the Rehabilitation Act, somebody does not have to be able to perform all of the functions of a job necessarily. They have to be able to do all of the essential or fundamental duties, essential functions. Sometimes there are functions that are not performed very often. The consequences of not doing them aren't very significant. There are other people to whom they can be allocated, and they may not be essential functions. And if those are functions that the person can't do while teleworking, that's okay. You can still grant telework accommodation, and maybe those functions can be reallocated to other employees. And it might be possible to give the person who is doing telework some other marginal functions, less significant functions, that he or she can do instead. If some functions need to be performed in the workplace, determine whether a part-time telework schedule is possible. I just said that, so just talked about that. How to determine if telework is an effective accommodation. So this has to do with not only whether it can you do the essential functions from a remote location, but is it going to be something that works for both the agency and in terms of getting its work done, and for the individual in terms of meeting whatever medical needs he or she has that necessitate the telework. Factors that can help determine whether some or all essential functions can be performed from home include, can the employee be adequately supervised? Sometimes that's the case. I know that I'm managing someone who is a remote worker on a full-time basis. I still supervise that person's work. The fact that somebody requires supervision or even close supervision doesn't necessarily mean that the person can't telework as a reasonable accommodation. What does supervision mean? It may mean different things in different kinds of jobs. Performing essential functions, if performing essential functions, does it require access to equipment or tools that can't be replicated? So that would make it not possible if somebody had to use tools and equipment that are only available in the workplace. Does the job require face-to-face interaction with other employees? Is in-person interaction with outside colleagues, customers, or clients? Is that critical? Does the job require immediate access to documents that can only exist in the workplace? And sometimes the documents may only exist in the workplace because there are security issues that may exist with making them available off-site. I wouldn't jump to that conclusion immediately just because information has some personally identifiable information, for example, like the names of individuals, social security numbers, etc. Does that mean that you can't work with it off-site? Well, maybe you can't, but it may be something that if the person if it's available in some electronic form and the person has access to a computer with adequate security, that maybe those documents can be accessed. Jobs essential. Here are some examples of cases where the job's essential functions could not be performed from home. We'll give some examples of other things as well, jobs where they could be performed from home. But Livonia M. Versus Social Security Administration. And this person was a benefits auditor who requested full-time telework because of chemical sensitivity. This is one of those cases where there was equipment, namely there was a telephone number that the person had to be able to answer. But sometimes calls would spike. You might not know when that's going to happen. Calls would spike, and somebody in this position would have to be able to field those calls, and they could only be fielded from a telephone within the workplace. I don't know why that was, but apparently we found, ESC found that there was evidence that, in fact, the equipment to respond to those calls existed and could only exist only within the workplace. Full-time telework was not a reasonable accommodation. So equipment that's available, that has to be accessed, that's available only within the workplace. Another example, Kathy M. Versus the Department of the Air Force. and this is a complainant who's a food service officer, whose responsibilities included overseeing operation of a restaurant and collection of receipts from a cash register. Well, that's probably going to be the kind of job she wants to take 2 days of telework. It was hard for me on the surface of it to see why someone would even make that request with certain functions seeming so obviously to be the kinds of things that you need to do from work. It seems hard to understand unless you had somebody else who actually did the supervision and collection of the receipts on the days when she could not be there. But then my question that arose in my mind was, what functions would she be performing? There might have been other functions that didn't involve in-person presence at the facility, but it wasn't clear to me. But in any case, the EOC accepted the fact that, agreed that the agency was not required to grant the 2 days of telework. Another case, Everett versus Grady Memorial Hospital, is the next case. And this involved an individual who, she ran a car seat program for a hospital that involved educating, providing car seats to individuals who might not have them, might not be able to afford them. They would provide car seats for newborns. One of the things that she had to do was meet with individuals who were receiving the car seats and train, educate them and train them in the proper use. And as somebody who a long time ago now used car seats for a child, I would bet that the amount of time that you had to spend educating people on their proper use could be significant if you had a lot of people that you were working with. In this particular case, those kinds of functions accounted for 10 of 32 hours of each week, and the court concluded that that was a reasonable accommodation that could not be performed from home. Credure versus Louisiana through the Office of the Attorney General. This is a case involving a litigating attorney, and the employer a litigating attorney who requested telework, and the employer allowed telework only rarely and temporarily. There were supervisors who testified that the job was, quote, interactive and team-oriented. Again, I want to caution everybody that just labeling something interactive and saying that you have to work as part of a team, that doesn't mean that you can't perform the job remotely. But in this particular case, there seemed to be a lot of evidence that in-person communication was important. The supervisor who, and then the individual had said, well, there's somebody else. There's a supervisor who actually teleworks. And the court said, yeah, that's true, but the supervisor who teleworks did so in addition to the normal business hours during which she worked. So this was taking work home is what this was. And there was another attorney that the employer or that the employee had presented as a possible comparator, but the court said that was not a litigating attorney. Their functions were different. Other employees had to sit, and I think this is really the important part. This is the important part for me, because the team-oriented and interactive part maybe could be accomplished in some other way, depending on what that really involves. But other employees had to assume some of the plaintiff's responsibilities, and plaintiff failed to complete certain required job tasks, such as adequately accounting for time. So that's really the critical thing. That when the person is teleworking, other people, there are certain functions that other people have to pick up, and the person couldn't adequately, for some reason, account for his time. But then, in a case Mosby Meacham versus Memphis Light, Gas, and Water from the Sixth Circuit, this was an important case for me from EOC because a couple of years before this case, there was a decision in the same circuit called EOC versus Ford Motor Company, in which the Sixth Circuit said that the employer did not have to provide 4 days of telework for an employee with irritable bowel syndrome. And in doing so, the court seemed to have a rather narrow reading of when telework could be required as a reasonable accommodation. And it was a case that was of quite a bit of concern to us. But this is the same court, the Sixth Circuit, saying in this case that an in-house attorney asked to work from home for 10 weeks while on bed rest for pregnancy complications. And the employer says that physical presence was an essential function of the job. Why did they say that? Because there was something in the position description for the attorney's position that said that she might have to try cases and take depositions. But what were the facts? The facts were that in the 8 years that she had been performing this job, all of the time that she had performed the job, and this isn't surprising for an in-house counsel position, she had never taken a deposition and she had never gone to trial or never had to try a case. And the court upheld the jury's verdict for the plaintiff, noting that while trying cases and deposing witnesses were part of the attorney job description, she never had to do that. And this is important because for us at EEOC, when we're looking at what the essential functions of the job are, we're going to look beyond just what that position description says. If there's some dispute about what that position description says, it's great to get something in a position description and identify it as an essential function. But what's really going to be important to us is what people in that job are actually doing, not what's in a position description necessarily, but what people are actually doing. May an employer make an accommodation to avoid the need for providing telework? And the answer is yes, if an alternative accommodation would be effective. And an example is an employee with a disability asked to telework because he uses paratransit and the schedule will not allow him to get to work by the employer's regular 8:30 a.m. start time. If a modified work schedule that would allow the employee to arrive later and to work later would work, that could be an effective, reasonable accommodation instead. Telework and leave. If telework would enable an employee to avoid use of leave, it should be provided instead of requiring the employee to take leave. The rule is that the employer gets to choose from among effective accommodations. If there's more than one accommodation, the employer gets to choose the one that's easier to provide or less expensive, but the employer should give primary consideration to the choice of the individual with the disability, and whatever the employer ultimately chooses has to be effective. And for ESC, an accommodation that can be granted without undue hardship and that would enable the person to continue working is an effective accommodation as opposed to leave, which may be effective in some cases where it's really the only alternative, but when you but as compared to telework, which would enable the person to continue working, leave is not going to be an effective accommodation because it's an accommodation that prevents the person from working during the period of leave. Okay. Okay, so the next case or the next slide, we're going to talk about performance and conduct issues related to telework. And my computer keeps turning off. Sorry. So sometimes issues come up with individuals who may have, and we saw this earlier with this Natalie S. case, may have had performance or conduct problems that make them ineligible to get telework under the employer's regular policy. And or you may see situations where someone is teleworking and their performance during the period that they're teleworking is not good. And they're teleworking as a reasonable accommodation, and their performance is not good. And in those cases, sometimes instinctively what the employer wants to do is say, well, you can't have telework because you violated this rule. You fall outside of the policy. You can't get telework. Or telework mustn't be a good accommodation for you because you're not doing well in your job. And so we're going to take that accommodation away from you. And I compare that to, a situation where somebody uses assistive technology like a screen reader, which is one of my pieces of assistive technology that I use, and the person's work performance is poor, and the employer says, well, the screen reader mustn't be doing you any good, so I'm going to take it away, even though you can't read the screen because your work performance is poor. So you don't, typically you don't take the accommodation away because the person is having a performance problem. What you generally do is treat that accommodation or you treat that performance or conduct problem like a performance or conduct problem. You discipline the person appropriately. You counsel them if necessary. You follow through with what your normal procedures are for handling performance or conduct problems. So Humphrey versus Memorial Hospital is just an example of this, and it was someone who had obsessive-compulsive disorder, couldn't get to work on time. The employer tried, and she was disciplined for that. The employer tried a couple of accommodations where they would ask her to call in if she was going to be late, but she couldn't do that. And then she requested, she was a medical transcriptionist, she requested to be able to telework or alternatively leave, and the employer didn't consider the telework accommodation. And this is a situation where, again, you might have to modify the telework policy, which says if you've been disciplined, you can't get telework, in order to provide telework as a reasonable accommodation. And that seems particularly true in this situation where the disability really does seem to have been and the inability to get the right kind of accommodation seemed like they were the reasons for some of the performance problems that she had and the punctuality problems that she had. So can't just automatically dismiss that request to telework. What if poor performance or misconduct is not attributable to a disability? And here's an example, an employee who has been working from home 2 days a week and whose performance has fallen below the fully successful level while teleworking for 3 months, has her right to telework revoked for at least the next 6 months pursuant to agency policy. So this is someone who presumably was working under the normal policy, can't comply with the policy, she's not meeting the standards to continue to receive telework. 2 weeks after the telework arrangement is revoked, however, the employee submits a note from her doctor stating that she has fibromyalgia and chronic fatigue syndrome, having to commute, and that having to commute to the office 5 days a week is exacerbating her condition. The doctor recommends a schedule that would enable the employee to avoid commuting on 2 or more consecutive days. So the tendency here is to look at this and say, this is obviously a phony request for telework as a reasonable accommodation. I'm not even going to consider it. That might be what some managers, supervisors would say. I'm not even going to consider it because it was 2 weeks after she was terminated from the telework arrangement, and she is asking for an accommodation that, although it's phrased a little bit differently, essentially looks like she wants at least 2 days of telework a week, or up to 2 days of telework a week. Don't ignore this request. That's my advice. You've got to process it like any other form of reasonable accommodation. You can try to determine the credibility of the information from the doctor. You might want to have some information about how long how long the doctor's been treating the individual. Is this something that is recently, is this a problem that with commuting that has recently occurred, or is it something that's been ongoing? You know, it is possible that the person was operating within the normal telework policy for reasons related to a disability, but didn't have to disclose to the employer that fact because the policy accommodated their needs. It wasn't an accommodation, but it met the person's medical needs. So don't ignore a request like this just because you think it looks a little bit suspicious. Go through with the interactive process. That said, if the performance is still poor, the person can be counseled, can be disciplined, can be given a poor performance appraisal, you know, assuming that she is entitled to get the accommodation as or the telework as a reasonable accommodation. You can still follow through with all the discipline. You can hold her to meet her standards and all the things that you would do for someone working, you know, at the workplace. Relocation for medical reasons. This is a little bit different kind of situation. At least one court has held that reassignment may be required as a reasonable accommodation to allow an employee to address medical needs. And that's a case called Sanchez versus Vilsack, case from the 10th Circuit in 2012. EOC would certainly, I think, agree with that position. A similar rationale might allow someone to telework full-time as a reasonable accommodation if medical needs require relocation and the job can be done full-time from a remote location. So if reassignment to another, I mean, I think, and in this situation, the employer might have some discretion as to whether it grants a reassignment or grants a telework from a different location. It might have some flexibility to choose between the two, although if the telework is a possible accommodation that can be done full-time from a remote location, then that would enable the person to retain their current job. But a reassignment would require downgrading the person. Then the telework is the accommodation that you would provide there. Agencies should also consider whether they have allowed other employees, for reasons not related to disabilities, to relocate and work remotely or to do the same job at another facility as a transfer. So, for example, in my agency, where my office and other offices have allowed people for reasons unrelated to disability to work remotely on a full-time basis, it'd be very hard for us to say if you need it for a disability and you're in the, you know, say, sort of otherwise similarly situated, it would be disparate treatment to say to the person, if you need it for a disability, we're not going to allow you to work remotely. That wouldn't be a reasonable accommodation. That would be just a matter of treating the person with the disability the same way you treat other remote workers. So if you allow other people to work full-time remotely, then you may need to consider, or you may have to allow somebody who needs to work remotely for reasons related to a disability to do that. With that, I think we're done, and I think we've got some questions, I believe, and I'm happy to jump into those.
Yes, Chris, thank you so much. That was a lot of information that you shared. Before we go to the questions, I wanted to remind our audience that the slides are available for download in the right bottom hand corner of your computer. So we're going to go right ahead and get into questions.
Yes. So, Chris, the first question comes from the chat box, and it was, do agencies have a specific time frame to respond to a reasonable accommodation request?
Agencies should have specific time frames for responding to reasonable accommodation requests. Executive Order 13164 from 2000, which was on agencies developing written reasonable accommodation procedures. That's been in effect, obviously, almost 2 decades, and agencies in their that executive order and the guidance that we've done talks about establishing timelines. Doesn't say what those timelines exactly have to be, but that there should be timelines as part of those procedures. That's been reaffirmed, and the latest place to look for what should go in your procedures is a regulation that EEOC issued in January of 2017 on affirmative action for individuals with disabilities in the federal government. And that sets out a number of items that should be in your reasonable accommodation procedures, and they ought to include timeframes for processing requests, including, and it's a good idea to have interim timeframes as well. In other words, when we get the request, we'll contact the person within X number of days. That would be, we will, they also might specify that if medical documentation is needed, that while the agency is awaiting the documentation, it can put the clock on hold while it waits for the documentation to come in, and then begin counting again once it arrives. But definitely there should be a time frame within which the agency reaches a final decision on whether yes or no to grant it. And another thing, two related things about that. One is that for extenuating circumstances, if there are circumstances that the agency could not have anticipated in advance of the request that make it necessary to have a longer time frame, then the agency may be able to have a longer time frame than is specified in their policies. If, on the other hand, a reasonable accommodation is needed more quickly than the time frames would normally allow, like if you have a 30-day time frame for processing a request, but somebody really needs it for something that's happening in 10 days, and it's possible to process that request, that's what the agency should do.
Perfect. So that just part two of that question, which I think you kind of answered, but I want to make sure it's clear for the group. So if someone makes a request, and let's say they needed 3 months, and so it's dated August 1st, and the employer doesn't approve the reasonable accommodation until September 1st, should the employer reduce the length of time granted to the employee based on the date of the medical documentation?
I didn't quite understand the question. Initially you said 3 months?
So right. So if they needed to telework for 3 months, and
okay, the person needs to telework for 3 months,
and the employer receives it on August 1st, but they do not grant. So I guess they would need 3 months starting at that time. They grant the reasonable accommodation on September 1st. So is it 3 months starting from September 1st, or should they reduce it to 2 months now that a month has already gone by?
Well, I mean, I think it seems to me that something should be happening in that month. In other words, if somebody needs what telework as a reasonable accommodation for 3 months, and that need becomes known on August 1st, and they ask for that telework. Now, maybe it's something that's going to not start. The need won't be until sometime in the future, but let's assume that they need it, pretty quickly after making the request. The agency, I think, in the first instance, should process that request. I would hope it would be more quick than 30 days.
Okay.
And I would also think that during that 30 days, something should be done because the person still needs something. It's not, the request hasn't been processed, but the individual still needs something. So my question, I guess, would be what's happening to that person in the interim? Is the person on leave? Are they on unpaid leave? Can the agency provide on a temporary basis telework? That's probably what I would do. I would say we're still processing this request to see if you really are entitled to receive telework as an accommodation. But in the meantime, if it looks like there's a good chance that the person will, we're going to put you on telework right now. If we determine that you'll continue to need it, then we'll provide it for the rest of the time. And I think in that instance, if the agency put the person on telework while they were making the decision, then you could probably reduce the request to 2 months from September 1st, because presumably they needed 3 months from August 1st. So you might be able to reduce it from and instead of having them come back to work regularly starting December 1st, which would be 3 months from September 1st, you might be able to say, well, you already had your month of telework, you get 2 more months because your request was essentially for 3 months starting August 1st. So I think that would be fine.
All righty, perfect, thank you. The next question is, I believe this is in regards to your first scenario, and the participant wanted to know, how is caring for a family member a disability?
It isn't. It's not a disability. And that's a very good question because we are sometimes asked whether individuals can get reasonable accommodations in order to care for family members. They can get FMLA leave. I don't know whether this person would have qualified for that or not. It was a father-in-law, so I'm not sure. But they can get FMLA leave to care for a family member with a serious health condition, but they can't get under certain circumstances. But they can't get a reasonable accommodation to care for the family member. It wasn't caring for the family member that the person was claiming was the reasonable accommodation. What the person wanted to do was to move out of the Minneapolis area to care for the family member. That apparently, it's the way I read the decision, that apparently was okay with the agency. In other words, people could move away from and get some sort of remote work situation as long as they came into the main office 1 day a week. And I've seen situations like this. The person wants to work remotely, and the agency says, yes, you can do that. Yes, anybody can do that who requests it and who qualifies, but they have to come in to the office once a week. And it was that requirement to come into the office once a week as part of the remote work policy that the person couldn't fulfill. So in this decision, we said, if the reason the person can't come in 1 day a week is because disability prevents commuting, then an appropriate accommodation might be full-time telework, or as the person had proposed, going to the Milwaukee office 1 day a week, which would still allow the person to come into an office, but would be much closer than Minneapolis. So it was. I know it's kind of confusing, and that's why I highlight the case, because the case was not about give me an accommodation so that I can care for a family member. It was give me the right to relocate to care for the family member, which you allow other people to do. And as part of giving me that right to do that, by the way, I have a disability that's going to prevent me from doing the 1 day a week, coming in the 1 day a week. And that's what I want the accommodation for. I hope that's clear, but I suspect it probably is not.
Thank you. And participants, if it's not, please don't hesitate to reach out. The next question for you, Chris, is when should an employee ask for a telework accommodation, during the hiring process or after the job offer?
I think that is up to the individual. The person is not required to ask for anything prior to employment as a reasonable accommodation. But some people choose to make that request earlier, and it's a very personal decision. The fact that someone has made a request after a job offer or after beginning employment and didn't make it earlier should not mean that the employer denies the request or holds against the person the fact that they didn't ask earlier. So people will choose to do it at different times. And in some instances, it may actually be the case that the person couldn't have anticipated or wouldn't have anticipated the need for telework earlier. I mean, if during the hiring process, I guess the question assumes that during the hiring process, the person was aware of the fact that she or he would need the telework. And in that case, again, it's up to the individual to decide when to make that accommodation request. It does not affect at all the agency's obligation to process the request and make a determination.
All righty, thank you. Couple of more questions, hopefully we'll get to them. If the employee has obvious cognitive difficulties and severe memory issues, can the supervisor request a reasonable accommodation on behalf of that employee?
The supervisor should not do that unless the a request can be made by a third party, that's for sure. And I would not recommend, I think that in certain circumstances, if the supervisor has that information, has medical information about the individual, that they might be able to disclose it in connection with making a request for an accommodation or implementing an accommodation. But I would not do that without involving the employee in that decision-making process. I would absolutely not do that. So you have to agree to that type of arrangement for the supervisor to make the request. Otherwise, what you should do is, if the person is having job-related problems because of something that the employer thinks is a cognitive issue, then the supervisor could say, could make the person aware of what the problems are with the performance, what the consequences are of continued poor performance or non-performance, and could say to the person, we have various resources that can help you, and if there's anything that we can do to assist you, including, and I think it would be okay at this point, including if you want to make any kind of accommodation request or seek any other kind of assistance, I can help you do that. So that's normally the way I would approach a situation like that. I would not ever go as a supervisor on behalf of somebody who I thought needed help and make that accommodation request on my own.
Alrighty. One more question. Seems like it's a little bit of a scenario. Say an employee has a flare-up from, say, arthritis. Taking the medication, it would help to reduce the pain. Which would be a better accommodation, leave or telework?
I think, well, I'm not sure how the medication ties in. I thought the question was going to be, could you tell the person that they have to take this medication to reduce the pain related to the arthritis so that you could, wouldn't have to provide the accommodation. Sometimes we do get those questions. Could I tell the person you've got to be compliant with your doctor's orders? Yeah, the answer to that is no. If somebody could be taking some other form of, some other type of medication that might work better or could have surgery to alleviate the problem, it's not the employer's role to say, you should do that, I'm not going to give you an accommodation. You sort of take the person as you find them, whether they take the medication or they don't. If the person doesn't take the medication and as a result can't do the job even with a reasonable accommodation, then the person wouldn't be considered qualified. But the fact that the person isn't taking some medication or some course of treatment that the employer wants doesn't mean the employer can ignore any accommodation request. Now, I'm not sure how the medication fits into whether leave or telework is a better accommodation. If the person is having pain related to the arthritis, but the person could still is having too much pain to really travel to the employer's place of business, but can function at home and get work done teleworking, then that would be the preferable accommodation to leave. There may be, of course, situations in which the thing that prevents the person from getting into the workplace also is going to prevent the person from doing job-related tasks at home. And where that's the case, telework's not going to be an effective accommodation, and you would provide leave as a form of accommodation, or according to your normal leave policy.
Well, thank you, Chris. I really appreciate all of your time and your sharing that very valuable information with our audience. We have come upon our time of 3:30. Again, if we did not get to your questions during this Q&A period, we will be sure to answer the questions at a later time. I want to thank everyone for joining us here today. And again, resources and contact information is there for you. If you want to reach out to the OPM team,